Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida, and I'm going to talk today about prosecuting claims for theft of trade secrets. We do a great deal of work in the trade secret space. Most of that is on the defense side, but we also prosecute these sorts of claims. So today I'm going to lay out my blueprint for prosecuting trade secret claims. Much of this is based on my experience successfully defending these sorts of claims. So without further ado, let's get into the mix. Number one, before you sue somebody for theft of trade secrets, make sure that you actually have trade secrets. Now I know that sounds a little bit silly, but every couple weeks I hear about another case in which the plaintiff sued for theft of trade secrets, goes through litigation for months or years, and then it winds up coming to light that the plaintiff never had trade secrets, that they sued in bad faith, that the case was frivolous, and the plaintiff winds up having to pay the defendant's attorney's fees to the tune of several $100,000. So before you go firing off a lawsuit, even though that may be your immediate inclination, you'd better make sure that you actually have trade secrets. Now, once you know you have trade secrets, let's get specific. That's number two. Get specific. I have seen a number of trade secret cases, and I've defended a number of cases in which the plaintiff adopted the everything and the kitchen sink approach. By that, I mean, rather than alleging that 2 or 3 specific trade secrets are at issue, they plead a laundry list of supposed trade secrets. I'm going to give you an example from an actual case that we litigated, one where we defended the company accused of stealing trade secrets. And let me read to you what my clients were accused of misappropriating. Customer lists, customer identities, purchase and credit information, sales and operation procedures, software, system architecture, financial data, sales and marketing strategies, statistics, programs, research, development, employee personnel and contractor data, information related to products and services offered by the company, and the list goes on. That's a laundry list of different categories of information, and it really is meaningless. In fact, we had that version of the complaint dismissed under Twombly for failure to state a claim. Now they repled, they came back with a little bit more detail in terms of their allegations, but ultimately it was to no avail and we won that case anyway. So that's the wrong way to do it. Don't plead a laundry list of different trade secrets. There are some attorneys who seem to think that more is better, that by adding more different trade secrets, more different categories to the mix, they make it longer, they make it uglier, they make it bigger. That's nonsense. That makes the case so much weaker. If someone actually misappropriates your trade secrets, the best thing you can do is not throw in a catch-all and try and be as comprehensive as possible. The best thing you can do is be specific about what is stolen. It makes for a stronger complaint and it makes for a far more credible complaint. For instance, a couple months ago, there were 3 Nike employees who jumped ship, went to Adidas, and had taken a whole bunch of information with them. And specifically, they took sort of a blueprint related to a specific division within Nike, and they took information related to upcoming product developments, right? Product releases that are coming out, sponsorship deals with athletes, etc. So get specific if that's what they took. If they took a strategic blueprint that breaks out the direction of the company for the next 3 years, or endorsement deals that are being targeted for the next 3 years, that's what they stole. That's the trade secret. You need to get specific. Likewise, if they stole a customer database, then you need to get specific and say they stole a customer database, here's what it contained, and here's why that was confidential and proprietary and constitutes a trade secret. Remember, specific and targeted is always better than going sort of generic and broad. And that applies in the context of discovery as well. Because if you put at issue 2 or 3 discrete trade secrets, then that's what discovery is going to focus on. And it's much more manageable for you to conduct your discovery, and it's also much more manageable for you to deal with the defendant's discovery coming at you. If you put 30 or 40 different trade secrets at issue, you had better expect aggressive discovery from the other side. They are going to want you to identify everything related to those 40 different trade secrets. All that does ultimately is drive up the amount of time and money that is spent on discovery and ultimately drive up the cost of the litigation. It's a waste of time. Lots of firms pursue that direction. They don't do it to serve your interest. They only do it to serve their bottom line. Number 3. If you've decided you have trade secrets and you've gotten specific and you're going to file a lawsuit, you need to pick the venue, federal or state. Get into federal court if at all possible. If you have diversity, great, file in federal court. If you don't have diversity, then you need to consider whether or not there are any other federal causes of action at issue. For example, you may have a Computer Fraud and Abuse Act claim. In such instance, you would file in federal court, you file your CFAA claim, and you bring your trade secret claim as a pendent state law claim. However, you have to be very careful pursuing that sort of approach. I've seen it happen a number of times in CFAA cases where the court kicks the CFAA claim, because lots of people plead a CFAA claim without understanding what the actual elements are there. The court kicks a CFAA claim, and then they say, we don't want to continue exercising jurisdiction over this state law trade secret claim, so we're just going to dismiss the whole thing and you can go have fun in state court. So, if you can't get into federal court, and you can't find a federal cause of action to get a pendent state law claim in federal court, and you know you're going to be in state court litigating the case, then you want to look at complex business courts, complex litigation courts throughout the state. There are a number of counties that have these. Miami-Dade has one, Broward has one, there's one in Orlando, and I believe that there's one in Tampa. In that scenario, you would file the case in state court, and then you would immediately make a motion to transfer it to the business court or complex litigation unit. Number 4, once you file a lawsuit, you should immediately seek an injunction. Injunctions are such that if you sleep on your rights, then you may not get an injunction. If you file a lawsuit and you wait several months to a year to seek a preliminary injunction, there's a very good argument that you're not facing irreparable harm from theft of trade secrets. Otherwise, you would have immediately moved for an injunction. So you want to sue, you want to immediately move for an injunction, immediately get a hearing on that injunction, and you want to begin building the record. Number 5, after you've gotten an injunction, you need to start thinking about trial. If there's any possibility that the case is going to proceed to trial, if there's any possibility that you are going to be able to recover damages, then you need to look at trial. What does this mean and how does this impact the litigation? From my experience, one of the most important things you can do is write your jury instructions. Jury instructions are the key to any and every case that goes to trial. Jury instructions ultimately tell the jury, here's what the plaintiff's claim is, here's what the plaintiff has to prove, has the plaintiff proved X, Y, Z? If so, then you have to vote yes, and if not, then you have to vote no. Everything comes down to jury instructions. So in a case like this, if you get through the preliminary stages and it appears that trial is a possibility, you need to get your jury instructions up in short order, and you need to work backwards off those jury instructions, come up with what is known as an order of proof, and lay out every piece of evidence in support of every element of every claim. That's what you need to do. So let's recap this. Number 1, make sure that you actually have trade secrets. Number 2, get specific about those trade secrets. Discrete and specific is always better than broad and generic. Number 3, pick your venue. Get into federal court if you can. If you can't, try and pursue the case in a state-level complex litigation or business court. Number 4, immediately get an injunction. And number 5, you have to begin looking at this from a perspective of trying the case, and that means getting up your jury instructions, getting up an order of proof, working backward from all that to make sure you have all the facts and evidence that you're going to need to ultimately prove your case. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. If you have a question or a concern about a non-compete or trade secret matter, please feel free to call my office. I'd be happy to talk. Thanks for watching and have a good day.